Yeah, there's a hand up.
Wonderful.
Excellent. Thank you, Rebecca.
Apologies for that slight divergence. We might just go straight to the contents of today's presentation. So we'll be taking you through the changes, the key changes that have been made to the Industrial Relations and Other Legislation Amendment Workplace Protections Act 2025. We'll also be focusing particularly on the new protected grounds that have been included. Under those new and expanded victimisation provisions, the role of the decision maker and the chain of decision making will be pivotal and take centre stage in the Commission's determination of whether detrimental action has been taken for an unlawful reason. And when addressing victimisation claims, decision makers must be aware of both conscious and unconscious factors that may influence their decision. So we'll spend some time considering those aspects of the amendments, and then we'll wrap up with some tips and takeaways. I'll hand over now to Andrew to take us through the key changes.
So the bill was introduced by the IR Minister and the Minister for WHS in May 2025. In introducing the bill, the Minister outlined the government's basis for doing so, stating the current government's position that for the last 12 years, the industrial relations system in New South Wales was systematically eroded by the previous government, leaving workers and employers worse off. They said that this government was and remains committed to establishing a modern industrial relations framework for New South Wales, which brings people back to the table and delivers better outcome for workers and employers. The bill introduced significant changes to the IR landscape, some of which we'll cover off today, and it received royal assent on the 3rd of July this year. So like I said, significant changes have come in through this amending legislation, including sexual harassment and anti-bullying jurisdiction, which adopts similar concepts to the federal space, allowing for applications for stop bullying orders, starting first with conciliation and leading to arbitration where that conciliation is unsuccessful, potential orders for damages, orders for prohibition on conduct, reasonable course of conduct to redress the loss being ordered, public apologies, and implementation of policies and programs. There's also new prohibitions in relation to sexual harassment in connection with work and sexual harassment disputes, and with orders similar to those in the anti-bullying jurisdiction being available. Those changes aren't live yet, but they'll be commencing soon. There are changes to industrial disputes, changes to victimisation, which we're focusing on today, gender equality changes, and changes related to WHS matters. So as I said, today we'll focus on victimisation changes, and there's been some new grounds implemented through this new legislation. But as a refresher, we thought we'd start with what is victimisation. So victimisation is where an employee is subjected to some detriment because of a protected attribute or reason. In that regard, it must be remembered that employees, or prospective employees, I should say as well, are subjected to detriments in their employment frequently, but only where that detriment is connected to some protected attribute is where it would be unlawful under this legislation. So in that respect, the causal link between the action and the protected attribute is important and critical, and a reverse onus arises whereby the employer must now prove that the action was not taken for that reason in answer to a claim. And we'll come to some important changes with respect to how to discharge that reverse onus in this presentation. So on the slide there are some of the new protected grounds that have been inserted. So they include making a complaint or inquiry about a person's employment or to a public authority about the person's employer, including matters about other than their own employment. So this is modelled, though not precisely the same as the federal system under Section 340 of the Fair Work Act. And while we wait to see how the Commission will interpret these provisions, we'll cover off some learnings today of what we can take from the federal system as to how this might be applied. The new ground 2 of characteristics under anti-discrimination legislation has been inserted, and I'm sure everyone on the call is familiar with such anti-discrimination concepts such as age, sex, disability, and the like. So what this does, while we're aware of anti-discrimination concepts, what it does is bring them into the victimisation provisions as well. There's been new protections, protected grounds in relation to workplace injuries and workers' compensation claims, and industrial relation activities, as well as right to responsibilities under other legislation. So focusing first on the complaint or inquiry, on the screen there is the federal provision and the new provision that has been inserted in the IR Act. So there's some notable differences between the federal provision and the IR provision. So, for example, is able to make a complaint or inquiry, whereas the state provision provides simply makes a complaint or inquiry. So in the federal space, those words is able to make a complaint, is able to make, I should say, have been the subject of judicial consideration to understand what precisely was intended to be meant by them. And the High Court has said the significance of the phrase is able to make has led to the observation that the ability to make a complaint must be underpinned by some entitlement or right to do so, which inferentially must be actually or presently held by the employee. But in the state jurisdiction, we don't have those words, we have only makes. So then we have to consider what we make of that difference. On its face, the federal jurisdiction could be said to be broader than the state jurisdiction in a sense, because makes could be seen to be the physical making of the complaint, as opposed to able to make, which is a concept, is able to make. But on the flip side, the federal system has been interpreted as requiring some source of entitlement or right to do so, whereas the state jurisdiction on its face doesn't have the requirement to have some right to do so. And it will be a matter to be seen whether the Commission interprets it in line with the federal findings on that entitlement grounding the right. So as it stands, the types of complaints that could be captured by the state jurisdiction are broad, and anything about an employee's employment. So, for example, complaining that the Tim Tams aren't offered on Friday afternoon anymore, that could be a complaint, if made, that falls within Section 210 now. And therefore, yeah, it can be trivial complaints, is what I'm getting at, as well as complaints, I suppose, that aren't grounded in an entitlement to do so, to make such a complaint. There are also differences with the bodies to which the complaints can be made. The federal system, you can see, provides to a body or person having capacity under a workplace law to seek compliance with that law, whereas the state simply provides to a public authority about the person's employer, including about matters other than their employment. So a public authority isn't defined in the IR Act. The Local Government Act does define its meaning as a public authority constituted by or under an act, and includes a person exercising any function on behalf of that authority. And the IR Act also has a definition of public authority, which includes a local government authority. So again, the state jurisdiction could be seen as somewhat broader in this sense, because it's the public authorities to which it applies don't apparently necessarily have to have standing or the ability to enforce obligations, as in the federal jurisdiction. But again, these will be matters that will be considered as this legislation goes through the Commission. I'll now hand over to Linda to speak further about complaints or inquiries.
So the Fair Work Act doesn't actually provide a definition of complaint or inquiry, and neither does the IR Act. So it will be a matter to be seen how the Commission approaches what a complaint is and how it chooses to define it. But federally, the term complaint has been held to indicate an expression of discontent which seeks consideration, redress or relief from the matter about which the complainant is aggrieved. And what we know is that a complaint is more than a mere request for assistance. and should state a particular grievance or a finding of fault. And in the decision on the slide in Shea and True Energy Services Proprietary Limited number 6, Justice Dodds-Streeton held that a complaint could be treated as having been made if the relevant communication would be reasonably understood in context as an expression of grievance or a finding of fault which seeks, whether expressly or implicitly, that the employer or other relevant party at least takes notice of and considers the complaint. So a case that considered whether what a complaint or an inquiry was is the decision of Alarm and National Australia Bank Limited, which is a 2021 decision of the full bench of the Federal Court. On the left-hand side of the slide, you can see a number of actions that were taken by the employee in this case, which she said were complaints or inquiries regarding her employment. And the full Federal Court was required to consider whether they constituted a complaint or an inquiry within the meaning of a workplace right under the legislation. So some of the actions that she took was she had an email seeking a username and a password. Another email was about the lack of IT access to work. There was an email seeking clarification of tasks to be performed, and she orally raised concerns about the behaviour of others at work towards her. So in the case of Alarm, Ms. Alarm was only employed for a short period of time, just over 3 months before she was terminated by NAB. NAB said that they had terminated her employment because she sent an email from her work email address to her personal email account, which attached some confidential customer information. And she was terminated because she didn't provide an adequate explanation for doing so. NAB denied that it had done that for any other reason. Had denied that there was any other reason for the termination. Ms. Alarm asserted that she had made 12 complaints during the 3 months of her employment, including those that are on the screen. So with that in mind, it's probably helpful to look at a few of these complaints and look at whether the court found them to be complaints or inquiries or not. So complaint 2 was an email that the employee sent to another employee, which stated, "I've attempted to send an email to get a username and password set up. However, I still do not have an account set up. Can you please advise what needs to be done here to complete this? I'm just letting you know in advance that without a login set up, I can't complete the training required, and the delay has also further impacted the time utilised for training completion." In this instance, the court said plainly that this was simply a request for assistance in establishing an account which Ms. Alarm required for her work, and it wasn't a complaint or an inquiry for the purposes of the legislation. Complaint 5 was an assertion that she had raised issues in a meeting with a colleague in relation to the behaviour of others at work, including, for example, exclusion of her from client opportunities and inappropriate allocation of work set for her. The court said that this is capable of constituting a complaint or an inquiry because the employee is raising a grievance about her employment that she's seeking resolution of. Complaint 7 was an email in the following terms: "I would like to discuss with you the types of tasks allocated to given roles and the operating arrangement between senior financial planners, associate financial planners and client service officers, particularly in light of the proposed changes. For the purpose of allocation of reasonable tasks appropriate to given roles, please let me know if we can discuss during your scheduled meeting with me." The court said that the employee did no more than request a meeting for the purposes of discussing particular work arrangements, and that was not found to be a complaint or inquiry for the purposes of the Act. The court further said that a complaint that an employee is able to make in relation to his or her employment is not at large, but must be founded on a source of entitlement, whether instrumental or otherwise, and must have some relationship to the employment. It is unnecessary for the employee to identify expressly the communication as a complaint or grievance, or to use any particular form of words. With respect to inquiries, the full Federal Court said its view was that it's possible that some requests for assistance may be able to be characterised as inquiries for the purposes of the Act. For example, an inquiry as to whether the recipient is able to provide the requested assistance. And so this decision further sort of quantifies what you can consider or constitute a complaint or inquiry in relation to employment. Now, the decision in Alarm actually endorsed previous reasoning of the court. Firstly, it has been found that there must be a relationship between the subject matter of the complaint and the complainant's employment, which comes from Walsh and Greater Metropolitan Cemeteries Trust, number 2, which was a 2014 decision. And secondly, that a complaint that an employee is able to make in relation to his or her employment is not at large, but must be founded on a source of entitlement, which instrumental or otherwise, which comes from the decision in Shea that was mentioned earlier. So noting the difference in the terminology between the federal and state legislation, which Andrew referred to previously, under the Federal Act it says is able to make, under the state legislation it says makes. It remains to be seen whether the Commission will adopt this approach, but it's useful to understand how complaints and inquiries have been considered in the federal space. In relation to complaints or inquiries, the cases have also considered whether a complaint needs to be made in good faith or is otherwise genuine. And in Shea and True Energy number 6, it was held that a complaint must be made genuinely in good faith and for a proper purpose. Now, in a further decision involving Ms Shea in Shea and Energy Australia Services Proprietary Limited, the court questioned whether genuine is a legislative requirement, and they didn't reject it. However, subsequent decision seems to suggest does include it. The full federal court decision of PIA Mortgage Services and King is a 2020 decision of the full bench of the federal court, and the full bench endorsed the requirement that the complaint must be made genuinely, in good faith, and for a proper purpose.
All right. I'm going to begin by making a complaint. I do not understand the need for the amendments that have been made to the Industrial Relations Act in this sphere of victimisation, for the minister to say that workers have been left worse off. The victimisation provisions have been around for a long, long time, since 1996. The Industrial Relations Act, save as to provisions relating to wages, has largely remained the same since 1996, and even a period before that, introduced by Labor governments, and has been one of the more effective industrial relations systems in Australia to be able to deal with employment matters, including as times evolve and emerge. But what we've ended up with is a system, as Andrew just highlighted, where you can't take any action against a worker because they make a complaint, in the broad sense of that word, to another public authority that might not be in relation to their employment. So a worker may make a complaint to a public authority, and in that absolutely defame, criticise, target and bully a manager, that you can't victimise them because of that, because they've made a complaint to a public authority about those matters. But that's not the worst of it. The worst of it is this concept of unconscious, and I'm going to come to that. But to understand the concept of unconscious, we need to understand how that arises, and it arises in the arena of looking at the cause. So Andrew and Linda have spoken about there being a protected attribute or a particular act like making a complaint, and what that is. But then there needs to be the causation element. And what that involves is, first of all, that there's some detriment taken against the worker, the employee. And the question then becomes, is why? Why was that detriment taken? And that's the causation point, where what one needs to look at is what is the actual reason that has caused the decision maker to take the detrimental action. Often it might be to take some disciplinary action, suspend or terminate an employee. What motivated them? And at least federally, it's been focused on what is the reasons of the actual decision maker. In other words, their subjective reasons. But as we're going to come to, the Industrial Relations Act amendments have thrown that out the window. When you're looking at causation also, not only do we keep in mind that what is required is a causal and therefore a factual inquiry into what are the reasons being made, federal courts have recognised that the fact that one makes a complaint, to use that new protected attribute that's been brought into the legislation as an example, the fact that someone's made a complaint doesn't give them immunity. And, you know, if people can complain about the Tim Tams not being in the lunchroom on a Friday, then in which case every employee has immunity and you can't touch them. That would be an absurd outcome. So the federal courts have recognised that the fact someone made a complaint 2 years ago doesn't provide a causal link to a decision being made today to terminate their employment or take disciplinary action. And equally, the courts recognise that the fact that you made a complaint 2 days ago before a decision is made to terminate you today also doesn't give you immunity. There's got to be some causal and factual link beyond the mere fact that it happened. Now, as we know, there's a reverse onus element that applies to these matters, and that's been in the Industrial Relations Act for a while, and it's certainly something that they haven't changed. But what has now been put in is that not only does the Commission need to work out objectively what was the substantial and operative cause for the detrimental action, but the Commission may also have regard to the unconscious factors that are at play. Now, the High Court, which is the highest court in this country, has said, at least in the federal scheme, the idea of having regard to unconscious factors would be an hilarity. It'd be a joke. And it would be a joke because if an employer has got to defend one of these applications and a manager's accused of taking action for an unlawful reason, the employer would ask them, why did you do it? And they'd give their reasons. They can't tell you what their unconscious reasons are because it's unconscious. They don't know it. So how does an employer then say, okay, we're going to defend it or we're not going to defend it? Because the manager doesn't know they've acted unlawfully, unconsciously. And if the business can't work it out, it begs the question as to how can the employer work it out. So we've come to a position where what Parliament has said when they put this law in is that the proposed amendment seeks to override the reasoning of the High Court and return to the reasoning of the court below. And what the court below said was, in effect, that they know better and they can work out what a person's real reasons were. What the federal court said, and this is where state government wants to go, is as follows. The determination of those questions, which is the question as to why a decision maker acted as they did, involves a characterization of the reason or reasons of the person who took the adverse action. The state of mind or the subjective intention of that person will be centrally relevant, but it is not decisive. So in other words, the court will have reserved for itself the ability to tell you you discriminated, you acted unlawfully. Now, that's going to have devastating impacts on managers that consciously and genuinely did not act unlawful. Yet we're going to have a court that will find otherwise. And what the federal court said is the real reason for a person's conduct is not necessarily the reason the person asserts, even where they genuinely believe that they were motivated by a lawful reason. The search is for what actuated the conduct of the person, not for what the person thinks he or she was motivated by. In that regard, the real reason may be conscious or unconscious. And where unconscious or not appreciated or understood, adverse action will not be excused simply because the perpetrator had a benevolent intent. And then, perhaps most dangerously, it is not open to the decision maker to choose to ignore the objective connection between the decision they're making and the attribute or activity in question. So, in effect, what this reasoning does, and this is why the High Court overturned it, is it in fact probably does get close to sometimes giving an immunity. Because if you're a good manager in 2025 and managing your workers, managing their performance, they will be making complaints about you. They will be making inquiries and challenging you. And you're going to know that. And when you go to get rid of them in terms of your performance, you can't ignore that objective connection. One would hope the Commission realises the potential stupidity of this law and brings it into the rare circumstance where perhaps a decision maker is saying they didn't do it for those reasons, but they're not a credible manager. And there is something actually wrong with their stated reasons, and you can find that they've done the wrong thing. But that's the unconscious danger. Unless you can get a hypnotist to give evidence, this is uncharted waters.
Sure. And with that in mind, it's now important to turn to the decision-making chain, because I suppose exploring the unconscious reasons of people in the decision-making chain is going to cause potential complications. So on the slide, and I might deal with this case in a little detail, you can see there on the slide that it does, in the federal system, again, it's referring to the conscious reasoning processes, but for our purposes, we could read that as conscious and unconscious, as James was just discussing, and whether such an approach will also be adopted in considering those conscious and unconscious factors will be seen. So this case outlines the proposition that the decision maker is not necessarily just the person who made the final decision, but will include everyone in the chain of decision making. So in terms of the background, you have Mr. Scott, who was employed by Claremont Coal, engaged in active union activities, making complaints or inquiries, and acting as a delegate for employees. He engaged in negotiations with the employer, was involved in complaint processes on behalf of members and so on. So he was actively involved in all those activities. Then in late 2014, a restructure was announced for operational reasons and economic reasons. And there were redundancies going on at that time, both forced and voluntary. So in terms of the forced redundancies, and stick with me on this because this is where you get into the decision-making chain. You have the redundancy selection criteria hierarchy, which was adopted to rank employees for redundancy. Selection criteria was based on 4 primary areas with some sub-areas. So the 4 primary areas were work performance reviews, performance management history, skills and competencies of the employee, and general attitude of the employee. And then there were, as I say, a number of subcategories under each of those. So employees were ranked according to that criteria and given a score for each, and then an aggregate score, and then they were determined who was going to be made redundant. Mr. Scott was ultimately selected for forced redundancy, and he said it was unlawful based on his protected attributes in the federal space. The court then had to consider the decision-making chain and stated there what's on the screen. So where the reasoning process is dispersed through an assessment process involving a number of persons, the task is much more complicated, requiring the judge to examine the reasoning processes employed by each person whose involvement had a material effect on the ultimate decision. It focuses on the conscious, and as I say, that we could read that as unconscious here as well, a process of those who had a material effect on the ultimate decision to determine whether their reasoning processes were free from the alleged prohibited reason. But if one or more of those reasons employed by one or more of them was prohibited, then it will impugn the ultimate decision. So in considering who had a material effect on the decision with respect to Mr. Scott to make his position redundant, it was a 2-stage process. First, an inquiry to ascertain whose reasons had a material effect on the decision that preceded that decision to dismiss him. And secondly, to examine the reasoning employed by those persons to ascertain whether it was infected by that prohibited reason. So Mr. Pretorius was the ultimate decision maker in relation to Mr. Scott, being the GM of the mine and the signatory on his termination letter. And the relevant players leading up to that decision were Mr. Christensen, being the first assessor under that hierarchy, and then Mr. Fleming being the second assessor. The reason for the assessment scores being so important was because Mr. Pretorius's evidence was that he could have not come to his final decision or ultimate decision without reference to the ranking spreadsheets and assessment scores provided to him by Mr. Fleming and Mr. Christensen. He denied that he was just rubber stamping it, the decision, but he was clear that those documents that were created as part of that ranking process were critical in his decision. Both Mr. Christensen and Mr. Fleming had interactions with Mr. Scott in the past, including in his union capacity and regarding complaints and so on. The evidence of Mr. Pretorius was that he wasn't really aware of Mr. Scott prior to the decision, which is not uncommon with ultimate decision makers sometimes. But because Mr. Christensen and Mr. Fleming had these engagements and had knowledge of these potentially protected attributes, that there was the potential that unlawful adverse action had taken place. So the court needed to consider whether the reverse onus was discharged in this case. In terms of the evidence of Mr. Fleming, the court was unconvinced that a substantial and operative reason for Mr. Fleming's assessment were not the complaints or industrial activities of Mr. Scott. And in this sense, they analysed Mr. Fleming's rankings of Mr. Scott against other employees. And I'll just give a couple of examples. So, for example, with respect to one criteria of skills, licenses and tickets, of the overall 135 employees assessed by Mr. Fleming, only 4 of them received a score out of 3, with everyone else receiving a score higher. So Mr. Scott received the lowest score along with 2 others. And when Mr. Fleming was asked to list the skills, licenses and tickets of Mr. Scott, he was unable to do so, even though that information was available to him in the computer systems. Another area was the attitude ranking, which was the final ranking in the hierarchy. Mr. Fleming was ranked as a 2, and of the 119 employees he had earlier rated in his first rounds, only 5 received a score of 2. And one employee who he ranked as a score of 3 had actually received a behavioural warning recently, whereas Mr. Scott hadn't. And there was no compelling explanation as to why there was that distinction, aside from Mr. Fleming saying Mr. Scott was sarcastic, but that wasn't accepted by the court. So ultimately, Mr. Fleming's evidence wasn't accepted. The court accepted that Mr. Pretorius's reason was not impacted by, Mr. Pretorius's actual reason wasn't impacted in terms of his own mind, but the decision-making chain was impacted because of Mr. Fleming's rankings based on those protected attributes. So Mr. Scott was ultimately successful and reinstated to his former position because of the unlawful adverse action that had been found. And it was, I suppose, a important lesson to learn that every link in that chain needs to be free of those protected attributes.
We thought we'd take you through another case, Lindfelt and QGC Proprietary Limited, which is a Federal Circuit and Family Court of Australia case from 2022. And it's an example of the collective decision-making that occurs particularly in larger organisations, including in local councils, when you're potentially looking at the termination or disciplinary action against an employee. In this case, Mr. Lindfelt, the applicant, was dismissed from his role. He was a FIFO gas plant operator, and he was dismissed during his probationary period. He claimed that he was subject to adverse action by QGC because he had exercised a workplace right. His employment was terminated because he said he made a complaint about the safety of the workplace. And as a result of the case, he was seeking $170,000 in compensation. So in terms of the collective decision-making, the Deputy Operations Manager had signed the dismissal letter and was the ultimate decision-maker, but the dismissal letter had been drafted by the HR department, which also approved the decision to dismiss. And the dismissal was also approved by the Employment Relations / Industrial Relations Manager, and that manager relied on the information from the HR officer that reported to her. And that HR officer had actually never met the employee until the dismissal discussion. And in turn, that HR officer had relied on the employee's supervisor. Mr. Lindfelt asserted that the operative decision maker was his supervisor and that the managers that were involved merely approved or rubber stamped the decision of the supervisor, whereas QGC's position was that the Deputy Operations Manager who had signed the dismissal letter and the Employee Relations Manager were the decision makers. So the court had to make findings about the state of mind of various individuals who constituted the directing mind and will of the corporate body who dismissed Mr. Lindfelt. No easy task. So the judge ultimately found that the supervisor was the most significant actor in the dismissal, observing that there had been a certain degree of sloppiness in the way the HR side of QGC had handled the termination of the employment because there had been issues around performance management, and the decision had been notified to Mr. Lindfelt during a teleconference. Judge Brown in this decision said, in my view, relevant decision-making at QGC in employment terms can best be described as being bottom-up, diffuse and hierarchical. In practice, to affect HR decisions, information passed up from the floor of the industrial workspace or workplace via immediate workplace supervisors to middle and then upper management, which was removed from the immediate workplace and therefore reliant on those below to enable it to make appropriate decisions. Many individuals with varying degrees of agency were involved in the process, which took time to be crystallised and occurred over several locales independent of one another. He concluded that on the preponderance of probabilities that QGC dismissed the operator because he was found not to fulfil the requirements of the position for which he had been recruited for operational reasons, and that his views about health and safety were not the reason or the substantive and operative reason why he was dismissed, and that he was not subject of adverse action because he raised health and safety issues in the workplace or for any particular protected attribute. But what this case shows is that even in a decision-making chain, or a collective decision making, which is quite common in large organisations, including local government, you can see that there will be inquiries made by the court or the commission, in this case, into the state of mind of the various individuals who are involved. I think that leads us to tips.
Yes, it does. I think there's 5 tips that really pop into my mind on how to deal with this new jurisdiction. The first tip, I think, is that when a complaint is made or when a protected attribute appears, as an organisation, you need to deal with it, resolve it and close it out at the time and in a way that is done as soon as possible. So that way you're able to make the argument that we dealt with it, we resolved it. Why would it still be motivating us all this time later? Or, you know, we dealt with it on its merits, there was no substance to it, so why would it motivate us in the decision that we're making? I think, and my second tip is in respect of, in particular, complaints, is that as an organisation, you need to be careful to not over-escalate or have matters dealt with at too high a level too early on. The reason being is that there is a nice beauty in decision makers up the chain not knowing about everything that goes on down below or not knowing of every complaint or inquiry that's made. Because ultimately, when they may have to make a decision about maybe terminating their employment or taking some other detrimental action, you need to make sure that they're not infected by that. And I'll come to that when I talk a little bit more about another tip in terms of how to manage the unconscious risk. The third tip I would give is, and this will be more particular to the HR people or the managers that need to prepare that brief that needs to go up for some disciplinary action or for some or a decision to terminate employment, is be very careful about what you include in those briefs. If it is truly the case that someone had made a complaint about Tim Tams every year, but that's got nothing to do with the serious misconduct they engaged in, why you would need to reference that in a brief going up, you'd really need to question. The second thing you would need to think about in these briefs is, do you need to make a recommendation? If you make a recommendation, you may then be a decision maker or someone who's materially taken part in the process, that then you need to also give evidence in the commission about the decision. And the more people that have their fingers in the pie, the more people that need to give evidence to rebut the reverse onus, the longer the case, the more expensive the case, the bigger the risk that someone says the wrong thing, and then victimisation is found because one decision maker is found to have an unlawful reason, and that then poisons the whole lot. The fourth tip, and I think this is probably the best way to deal with the unconscious element, short of can we get hypnotists to give evidence of what is in a person's unconscious, because I don't know whether there's anyone alive that, other than a hypnotist, that could do that. Is I think you've got to apply a conflict of interest lens to who is the decision maker. So if the decision maker to terminate someone for poor performance is the employee's direct manager, who has been the subject of a number of complaints about them being a bully, having them make that decision might lead to some cross-examination where they acknowledge all those complaints were made, they acknowledge that those complaints upset them, and that maybe unconsciously, even though the person's performance is really bad, maybe subconsciously, unconsciously, they've been influenced. So you might need to think about who's the decision maker. And that leads to the fifth tip, that maybe if you've escalated things up too much, you might need to think about, do we outsource the decision? Do we get someone outside the organisation to be delegated that decision-making function based on just the facts? Because, you know, those that complain a lot in employment, and I don't need to probably tell you a lot about it, but they've probably complained multiple times all the way up the top of the chain that it might be hard for anyone to not be unconsciously at risk of being found to have had that person's complaints over time influence their decision making. So you might need to consider, well, do we outsource the decisions to someone who has no knowledge of them and deals with for example, the serious misconduct on the facts? Even though I've got to say it should be a compelling argument to say, look how serious the misconduct was. Who cares that they've made 100 complaints? The fact they made 100 complaints and they're still employed before the misconduct is evidence that it didn't bother us. But maybe having someone else make that decision might be a good protective move against the unconscious element. So they're the tips. Does anyone have any questions they want to send to us? If not, then thank you very much. Yes, you will receive a copy of the slides. Yes.
Sorry, and that was the beginning where I don't think you could have heard me. You will receive a copy of the slides and a recording of the presentation as well. Thank you, everyone. Enjoy the rest of your day.
Thank you.
Thank you.